This morning, we have a very interesting program. Our own Mark Nichols is going to bring us up to date on what the prosecutor's office has been up to in the last period of time. And that's all I'm going to say because we all know him and I want him to speak as long as possible. So over to you, Mark.
Great. Thanks, Laurel. Okay, well, I think I'll get right to it, and I'll start with a little bit of a disclaimer. I'd put together an initial program about a week or so ago and had planned on talking about some of the pandemic impacts to the office and a few other things that have been going on. And in the intervening period of time, we had really a landmark case come down from our state Supreme Court entitled State versus Blake. And there's so many implications from this, and it's so significantly changed the legal landscape that I thought I'd spend the bulk of the presentation just talking about this, maybe answering some questions from the membership. It's really an interesting situation, and it's a demonstration of what can happen at times when you have court opinions handed down, especially from our state Supreme Court, which is, I think folks know, is the highest court in the state of Washington. And so when they speak, folks listen, and the law changes. And so with that, last week, Thursday, prosecutors across the state and criminal defense attorneys and frankly, the world was alerted to the fact that our state Supreme Court had decided a case and issued a written opinion explaining their reasoning. The facts of the case are really quite simple, and they involved a woman by the name of Shannon Blake, who was charged with felony drug possession after police in calendar year 2016 found a small bag of methamphetamine in the coin pocket of her jeans. She said she didn't use the drugs and was given the secondhand jeans as a gift just 2 days earlier. And so in legal proceedings, we say that she had asserted an unwitting possession defense. That is, she claimed that she didn't know that she had the drugs on her person. Because Washington's drug law didn't require that defendants were required to know that they had drugs on their person, she was charged and convicted, and this happened in the eastern half of the state in Spokane. In rendering the decision that it did last week, our state Supreme Court vacated Shannon Blake's conviction, and in doing so, and through the issuance of their opinion, they actually fundamentally changed the law in the state of Washington such that it is no longer illegal at present to possess controlled substances in Washington state. And when I speak in terms of controlled substances, I'm talking about methamphetamine, heroin, speed, ecstasy, fentanyl, compounds that have been strictly regulated, controlled, and deemed illegal up until this point in time. And that's been the state of the law in Washington dating back as far as 1971. So this is a change in approach to this subject matter after a 50-year period of stability. And so when we received the opinion Thursday morning, it put us on notice that there had been a fundamental change as to how Washington state was going to be approaching controlled substances, and it required us to immediately start taking a series of actions. And I would characterize these as consequences of the decision, some of which were likely intended by the high court, others of which may not have been. And so the first thing that we did was, effective Thursday morning, we stopped charging simple possession of controlled substance cases. And we have received those weekly for years from all branches of local law enforcement. The state patrol might stop someone for speeding, for example, and when asked to produce their license and registration, someone would open up their glove box. The trooper might observe a white baggie or a small plastic baggie containing white powder that in their training and experience appeared as methamphetamine. So they'd get a speeding ticket, but they'd also wind up being potentially arrested, and if not arrested, at least referred for prosecution for the crime of simple possession of methamphetamine. And so we stopped charging new cases immediately. Almost at the same time, we turned right around and took inventory of the county jail, and anybody who was currently in jail held on bail in connection with a simple possession of controlled substance case that was in process was immediately released on their own recognizance. And actually their case was dismissed outright. And that was on the motion of the state, because there's some liability that attached by virtue of the fact that we had people who were lawfully in custody up until Thursday morning, and then whose liberty was suddenly being deprived based on application of a statute that the Supreme Court had deemed unconstitutional. We also set about vacating the judgments of all persons in the jail who are currently serving time only for simple possession. And so, stated somewhat differently, if somebody had, for example, in February been sentenced to 60 days in the county jail for possession of methamphetamine, and they were in the process of serving their sentence last Thursday, they were immediately released and will not be required to complete the remainder of their sentence, again, because it was based on a statute that has now been deemed unconstitutional. We also worked with local law enforcement and our local dispatch center to recall all warrants that had been issued in cases in which the only charge is simple possession of a controlled substance. And so, for example, if maybe 5 years ago somebody had been charged with possession of methamphetamine or heroin or cocaine and had stopped showing up to court to confront legal process that had been filed against them, there may well have been a failure to appear arrest warrant issued for them, the purpose of which is to bring them back before the court so we could conclude the proceeding. All of those warrants were quashed based on some actions taken by the prosecutor's office in response to the high court decision. Because again, we didn't want to invite a situation where local law enforcement was picking someone up on an outstanding arrest warrant that was issued in connection with a statute that had been deemed unconstitutional. Additionally, we have been tasked with either dismissing with prejudice all cases in which the only charge is simple possession, or we're noting up a motion to file an amended information that charges another crime. And so, for example, if we had charged an individual with possession of methamphetamine, we are working with the defense bar to dismiss those cases unless there's another charge that we have the ability to charge in place of the existing charge, in which case we're doing that. Interestingly, and this is my sense probably an unintended consequence, but it nonetheless is one that we're having to contend with, we had to take inventory of our county drug court participant pool, which had about 60 people in it, and ask the question, how many of those folks were participating in drug court based on the fact that they had been charged with a simple possession of controlled substance case? And the answer was about 50%. So 30 of the 60 participants were in the program in connection with simple possession of meth or heroin or cocaine or ecstasy. You get the idea. Because the statute was deemed unconstitutional, we had to dismiss those cases as well. Because we dismissed the cases, the participants were automatically remanded from drug court, regardless of whether they wanted to be. And so this is really quite concerning, because we had folks, for example, who were not just in drug court, but they might have been at inpatient treatment, the cost for which was being paid through the program, in essence, or by virtue of participation in the program. Once they were remanded from drug court, we needed to immediately work with the defense bar to have them removed from inpatient treatment or outpatient treatment, as the case may be, because we couldn't legally continue to expend public funds advancing their recovery effort once there was no longer a lawful basis to have them in the program. And so that's created some public safety concerns regarding what's going to happen to folks who are midway through the process of engaging in recovery and who are suddenly back out on the streets with little to no support potentially. We also have stopped the practice of including simple possession of controlled substance convictions in the offender score for people who are going to be sentenced in connection with other crimes. And this speaks to the fact that Washington has a Sentencing Reform Act, and under that legislation, when we sentence a person for a crime in Superior Court, the court looks at two different data points, one being the seriousness of the crime for which the person is being sentenced. And obviously, the most serious crimes are those such as murder or serious assault or rape. Less serious crimes are things like a Class C theft, Class C felony theft offense. And then in addition to looking at the seriousness of the crime, courts also look at the offender's score. The score is comprised of points, and each time you get a felony conviction, you accrue a point which drives your offender score up. And so if you think about this in terms of maybe an algebraic math grid, on one axis, you've got seriousness of the offense. On the other, you've got offender score. And where the two intersect, you have a sentencing range that circumscribes, by and large, the sentence that a defendant will receive upon pleading guilty. We need to go back now and essentially remove all of the points that have been contributed to individual defendant scores that stem from a conviction for possession of controlled substance. And so, for example, if somebody has 5 prior convictions for possession of methamphetamine on their record, and then they get in trouble for a residential burglary crime, when they're sentenced, their offender score is going to be 5 based on the fact that they have 5 prior possession of drug convictions on their record. That's going to drive their sentencing range up to the point where they're likely in a prison range sentence. For many folks who are serving prison sentences right now, based on the fact that they have a higher offender score because of past drug offense convictions, they're actually likely going to wind up being released from our state prison system, because once we recalculate their score after having washed aside these convictions, many of them will be in and have served their time under the new sentencing formula. And in addition, we're ceasing the collection of legal financial obligations in cases in which the only crimes were convictions for simple possession of drugs. Legal financial obligations include things like victim penalty assessments, monies from which go to support crime victims' rights at the community level. They also include things like fines that were entered and remitted to the county's drug court program or the regional drug task force program here in Clallam County. They can include other fines such as a $100 DNA collection fee. And last but not least, we're preparing to deal with a raft of motions filed by defense attorneys seeking to have prior convictions vacated, and not just for simple possession of controlled substance cases, but frankly for any case in which the basis for the investigation stemmed from a simple possession of controlled substance contact by law enforcement. And so this is going to become a very, very involved process that's likely going to take months to years to fully sort out, but it's going to have the effect of, again, reducing our state prison population, reducing to some degree the county jail population, although it's already been kept at a minimal basis based on the pandemic that we're confronting and grappling with at present. And then we're going to have to go about essentially undoing these convictions. The reason why this is going to be such an extremely involved process is because the Supreme Court's opinion is retroactive. And so that means that it reaches back in time And Washington enacted the statute at issue initially in 1971, the year I was born. So we need to reach back essentially 50 years, look at every person in Clallam County who pled guilty or was found guilty of this offense, and we're going to need to take these remedial actions as to each and every one of those persons. A few of the more involved issues that raise questions that have yet to be answered involves who's going to pay for the reimbursement of legal financial obligations. Because interestingly, as a result of the court's opinion, let's say hypothetically in 1980, somebody was convicted for possession of methamphetamine in Clallam County. In addition to incurring the Class C felony conviction on their record, which would have the collateral consequence of precluding them from being able to lawfully possess firearms, it might have precluded them from being able to vote for a number of years unless those rights were restored. They were also ordered to pay LFOs, and in many cases, the LFOs that were ordered are into the thousands of dollars. Now that the Supreme Court has held that the statute at issue is unconstitutional, the legal financial obligations that were ordered and paid by a defendant are going to need to be refunded to them. And so the question is whether the refund is going to come from the state of Washington, or if instead the state's going to take the position that Clallam County is on the hook. And so I sense this is probably an issue where we're either going to find a way to reach resolution and agreement up front, or there's going to be litigation over that issue, because the preliminary cost estimates indicate that this may well be a $100 million type of reimbursement exercise. So we're talking a large sum of money. As previously touched on, county drug court programs across the state are now in jeopardy, especially in smaller counties with smaller participant pools that were primarily made up of people who are in the program in connection with the simple possession of drug charge. In addition, we have something called the drug offender sentencing alternative. And so for people who have not been interested in entering into the drug court program, but who nonetheless wanted to receive help in connection with addiction issues, there was an ability to be sentenced under an alternative program that would, again, really provide them some access to treatment services and the like. With the elimination of the simple possession of drug charge, the question of these, the viability of these programs is going to be in question moving forward. And so that's something the county is going to need to take a closer look at. And then there's some really nefarious, I think, unintended consequences, at least I hope. And one of them involves that while minors in the state of Washington still cannot legally possess alcohol, so we have what's called a minor in possession of alcohol charge, they can now legally possess methamphetamine, heroin, fentanyl, cocaine, you name it, and they cannot get in trouble for that, at least from law enforcement. And so this sends a really mixed message. And to make matters worse, it's technically illegal for minors to possess marijuana in an amount less than 40 grams. But interestingly, if they possess more than 40 grams, it converts to a felony offense, and then they fall subject to the protections afforded from the new state Supreme Court decision. And so as prosecutor, one of the questions I've been asked is, in the aftermath of this case, are you going to continue to prosecute minors for possessing marijuana in an amount less than 40 grams? And my initial thought was, well, absolutely. I want to do everything I can to toe the line on this, because we believe that marijuana is what's characterized as a gateway drug. It has a number of effects on the young mind, and it's something that we don't want to freely condone the use of. But what I'm discovering is that in cyberspace, there's a number of blogs and informational sites that have already popped up, many of which are receiving a lot of views. And the prevailing wisdom being provided by attorneys across the state to youth is it's still illegal for you to possess minor amounts of marijuana So the answer is to make sure that you're always carrying more than 40 grams, and then you avoid prosecution. Well, this is a perverted result, and it's not one that I'm interested in promoting. And so there are no good options in relation to this. But my short-term solution is to not aggressively pursue possession of marijuana for minors in amounts less than 40 grams, because I don't want to send a message to kids in our community that the remedy for them is to go out and buy larger quantities. And so the list goes on with respect to consequences. Suffice to say, they are many, varied, and the court's decision raises more questions, frankly, than it does provide answers. This may beg the question, is there a solution to this problem? And I would characterize it as a problem, although not everybody would. The answer is yes. There are 3 tentative solutions that are being discussed at present. One involves that because the state Supreme Court has told the legislature that its statute is deficient and unconstitutional because it lacks a knowingly requirement, they could fix it, they being the legislature, by simply adding the word knowingly to the statute. That would have the effect of making it crystal clear that the law criminalizes those circumstances when a person knowingly possesses methamphetamine, as compared to circumstances where they didn't know that they had it on their person, or at least that was their claim. There was actually a Senate bill number 5468 that was introduced last week Friday, the day after the opinion came down, that would accomplish this very legislative fix. But what I'm hearing from folks in Olympia is that there is going to be bipartisan gridlock over this, and it's probably not going to be realized, which is unfortunate because this would fix it immediately and prospectively moving forward, either on a short-term basis until they could come up with a longer-term duration fix, or permanently. Number 2, there's a discussion occurring about revisiting a bill that received some attention earlier on in the legislative session, but that died on the vine for lack of support. And this would have the effect of essentially having Washington follow in the footsteps of Oregon and legalizing drugs to some degree, say, for example, decriminalizing maybe up to 5 grams of heroin or methamphetamine, and only criminalizing it if you had larger than that amount on your person, and directing some money towards treatment services instead of the criminal justice effort. That didn't receive adequate support through the last set of discussions, and so we question whether there's a viable chance of that passing, which speaks to the fact that, or the likelihood that there's a pretty good chance that nothing may happen, at least this session, which will leave our state in a situation where we are operating with a set of laws that do not criminalize the simple possession of drugs, period, which I think is a shame. And so that is my brief presentation, and I thought it might result in some questions being asked. And so, Chris, I'm going to stop sharing my screen and hand the electronic helm back to you. And at this point, we've got a little bit of time. I would love just to entertain questions either about this case, any of its consequences, or anything else related to prosecution, coroner, general goings on in the county.
I'm sure there's lots of questions.
Mark, I've got one. Maybe it's, maybe it's my old hat, and you might not be comfortable expanding on this, but if this is going retroactively all the way back to the beginning, and we've heard numerous cases where people were convicted of crimes that they were later found innocent of, and the government ended up paying them large sums of money due to civil suits for wrongful prosecution and liberty, and they're not allowed to vote, and they lost their right to, all kinds of things, multi-millions of dollars. What's the civil side of this going to look like?
Well, that's a great question. And what I will tell you is that society being as litigious as it is, we are expecting a significant amount of civil litigation practice in connection with this. I think that a lot of the claims we'll have to take the time to defend against them, and there's a huge cost in that process, as you know.
I do.
And so that, unfortunately, oftentimes cases they settle to essentially cap the attorney's fees from rising. But I think that in many situations, if someone is going to, for example, try to sue the state of Washington, the Department of Corrections, which runs our prison system, or the county, or the prosecutor's office for prosecuting them for a simple possession of methamphetamine in 1990, they can file that suit. They can make their demand. We will assert qualified immunity and point to the fact that we were enforcing a statute that was constitutional because it had not been deemed unconstitutional, and we were doing our jobs in the manner envisioned by the legislature and the courts. And I would like to think that the high courts in the state of Washington would see the reason of that argument and rule in our favor or dismiss the suit otherwise. But we are expecting suits to be filed claiming that folks were unlawfully imprisoned, their civil rights or liberties were violated. For folks who, maybe here's a good example, somebody got convicted in 1990 for possession of methamphetamine. As a result of their conviction, they had a felony on their record. As a result of the fact that they had the felony, they were precluded from being able to lawfully possess firearms. And then 2 years later, they're found in the woods hunting by a sheriff's deputy, and so they're arrested because they're a felon in possession of a firearm. Well, we're probably going to have to set that conviction aside as well because it was predicated on a statute that has been deemed unconstitutional. Things could get worse because perhaps in addition to losing their firearm rights by virtue of their felony conviction, maybe they were unable to obtain certain security clearances necessary to work in certain disciplines that could have paid them a better salary or income over the course of years or decades. And so we're expecting that there will be creative attempts to argue loss of consortium, deprivation of liberties, probably intentional infliction of severe emotional distress. Interesting, by virtue of the fact that we did our jobs in prosecuting someone for a violation of a statute that was lawful at the time. So it's going to be a mess. And really for the county, one of the things that we're trying to determine right now, and this is a very difficult process because we have electronic records that go back only so far, and then we have to literally go back and try to find paper records all the way back to 1971. We're trying to get a better handhold on the volume of cases that we're dealing with. And I think we're probably talking about not cases in the hundreds, but rather in the thousands. And again, if we look at what's happened with respect to legal financial obligations, I think I may have talked about this a few years ago in a program, but it used to be the case that in Washington, there were a number of mandatory legal financial obligations that courts were required to impose at the time of sentencing. And so, for example, in 2010, if somebody was convicted of simple possession of methamphetamine in Clallam County Superior Court, they would be ordered to pay a $500 victim penalty assessment, the proceeds of which would go towards the provision of victim services in Clallam County. They would be ordered to pay usually a $500 fine or assessment to the Clallam County Drug Court Program, and that would be to help bolster that program to maintain its viability moving forward. They may well have been ordered to pay a $500 or even a $1,000 assessment to the County Drug Task Force to maintain the viability of that program. If they had never been convicted of a felony, they would have to pay a $100 DNA collection fee to cover the costs of the swabbing and the lab result and testing to get their DNA into the system. And so And then in addition, there's a possibility that there could have been restitution ordered, even though they may have pled guilty to a simple possession of methamphetamine charge. It could have been the case that the fact pattern involved them being high on methamphetamine, trespassing onto someone's property, and stealing something off their porch. And as part of a global resolution, maybe we said, you need to plead guilty to the felony, and you need to agree to pay restitution to the person whose property you stole as a component of the global plea. And so now one of the questions is, in addition to the legal financial obligations that were paid to the state of Washington and or the county, there may have been restitution paid to individual civilians who were victims in cases. And again, all of this is going to be the focus of an extraordinary refund or reimbursement effort. And my sense is the state of Washington will probably take the position that the counties need to reimburse a lot of these monies. The counties are, I think with better argument, going to take the position that the state should be on the hook to refund the monies. But it really doesn't matter, because with a hit of that magnitude, if the state agrees that it's obligated to pay this back, there's going to be less money to go around, and so it's going to impose hardship on Clallam County, just like the other 39, regardless of how this shakes out. Great question.
Mark, just with everything you're doing on the at the county level, so all the other counties are doing the exact same measures? Is it state dictated, or how does that work across, so it's uniform across all counties?
Well, and that's there is no requirement that counties approach this in a uniform fashion. However, at least within the 39 elected prosecutors, we've met several times already to discuss this, and we believe that there's tremendous benefit in having uniformity as between the 39 Washington counties and how we approach the state from a messaging perspective. And so we are trying to garner support, lobby different county commissioners from across the state, county sheriffs, county prosecutors, so that we can preach a common message to the state. Right. And then in a perfect world, this is a large enough, complex enough undertaking that it really makes a lot of sense for me to come up with a uniform statewide process to get right to your point, Scott. And this, I think it would look something like this. Every time a person petitions the Clallam County Superior Court to vacate their simple possession of drug conviction, the court would go ahead and sign an order vacating their conviction. A copy of that order would need to be sent to the state patrol so that that felony conviction could be removed from their criminal history record. The court would simultaneously include a one-line statement to the effect that the defendant shall be refunded whatever dollar amount is left owing to them as a result of legal financial obligations paid. And then what we'd like to do is have the defendant provided with the address of a state agency that could field essentially a claim for damages in the amount of the legal financial obligations that they paid, and have those paid out of a unified fund. If there needs to be argument over how that fund is populated and who's going to pay, that's a separate issue. But if we could come up with a very streamlined process that's going to be the same across the state, that would really increase the efficiency in responding to this.
Mark, I have a question. What was the reasoning that the state Supreme Court made this decision?
So the reason the court made the decision was really kind of twofold. But at the heart of it, the court was left grappling and needing to answer the question of, is it fair for a person who doesn't know that they have methamphetamine on their person to be branded as a felon for having it nonetheless? And so again, in this case, the case actually had nothing to do with drugs at inception. Law enforcement was investigating a car thief ring. There was a group of folks in Spokane who had been in the business of stealing cars and operating a chop shop. So they'd break them down and they'd sell off the component parts. the Spokane Police Department had been tracking this. They obtained a lawfully issued search warrant from a judge that allowed them to go to the chop shop, execute the warrant, and they were there for purposes of investigating this car theft activity. Shannon Blake happened to be one of the people who was found in the chop shop, and so they placed her in custody. When they patted her down, search incident to arrest is when they found this small bag of methamphetamine in her pant pockets. And so she did what a lot of people have done. We call it they're not my pants defense. And we've seen this time and time again in Clallam County. It's not uncommon. People will say, well, these aren't my pants, or this isn't my backpack, or what have you. That's exactly what Miss Blake did in this case. And the state didn't pay a lot of attention to it, which I think is a shame, because it allowed on appeal for the unwitting defense to go before the higher court. And the high court just looked at this, I think, from a fundamental fairness perspective and said, we just don't think that it's fair to criminalize, especially at a felony level, the unwitting possession of controlled substance. They also pointed out correctly that Washington state is the only state in the nation that does not have an express mens rea requirement built into the statute. That is a mental state requirement. That's why the proposed legislative fix would simply involve adding the word knowing to the statute to make it clear that knowing possession of methamphetamine is a crime, but unwitting possession would not be. Practically speaking, I can tell you that we have not been in the business, to my knowledge, ever of prosecuting people who were found in possession of controlled substance when they had a legitimate excuse. If they could not just claim they weren't my pants, but they could identify, my friend Jane gave them to me. Law enforcement go and talk to Jane, and Jane says either, yes, I let her borrow my pants and I knew there was methamphetamine in the pocket, or yes, I let her borrow my pants. And under those sorts of fact patterns, we would not prosecute in this county to avoid running into this problem. So they say bad facts make bad law. I think some of that rings true in relation to that, or to this matter. Part of what the Supreme Court did, however, does make sense because they've called out a deficiency in the statute. Again, there is a very clear legislative fix, but I think that unfortunately, partisan politics are going to prevent the legislature from likely making the fix, at least in a timely fashion.
Thank you.
Hey, Mark, good to see you.
You're welcome. Likewise.
We traveled around Portugal a couple years ago. Fantastic country. They legalized all drugs 20 years ago, and what a cool country. We have a very conservative friend who's a policeman in Washington State, and he said years ago, "Why don't we just legalize all drugs and deal with the behavior?" We've all worked with people who have serious drug problems, and we never knew it. I had an interesting thing years ago. Guy was very excited. He was going to hire an executive secretary away from somebody else. She's really good. He was really excited. She came in and got drug tested 3 times, really, really high on drugs. And he was very, very angry with me because he said, she's wonderful. She's incredibly competent. She functions just amazingly well. It seems radical, but it is kind of interesting. There are some people who can be on drugs and function amazingly well. And I don't care if somebody's, sober, drunk, on drugs or whatever. If we deal with the behavior, that seems to be really the critical issue. Comments, thoughts?
Well, I would agree. I think that if, in relation to the argument of legalizing drugs, I think it makes fine sense if people, after having consumed drugs, stay in their house, don't get behind the wheel of a motor vehicle, don't venture out and do things that violate the rights of others. But we know from experience that that's not what happens. Instead, some percentage of folks who use drugs will decide to get behind the wheel of a motor vehicle and perhaps get in a wreck that takes the life of another, or they will venture out and, judgment being impaired, do things like take others' property or get into physical altercations with other people. And this serves in and sounds in victimizing others. And so I think if folks who took drugs just stayed inside while they were under the influence and never left their house, that would be fine and great, but that's not our reality. And so I think therein lies the challenge, is in that if you're going to legalize drugs, are you inviting a parade of terrible and dangerous consequences? And that's where folks are oftentimes at loggerheads. And I think that's really part of what killed the legislation that was proposed earlier this session, which sounded in the partial legalization of drugs. On the one side of the equation, there were folks saying we should legalize drugs and just direct more money into treatment. And that's the best way for society to address this challenge. Opponent said there's a flaw in your reasoning, and it involves that if you decriminalize drugs, what makes you think people are just going to wake up one morning who are addicts and decide to go seek help on their own? There needs to be a hammer to force them to get help when they need it, but are unwilling or to see or to concede that they actually need it. And so you can imagine the back and forth exchange that occurred, with many saying you can't just simply legalize it and throw more money into treatment centers, because a lot of people who are addicts will just continue to use, not opt to go to treatment, and there will be all sorts of deleterious conduct and consequences occurring to others along the way.
But you know, Mark, that argument is, if you just substituted the word drugs for alcohol, you have all the same behavioral issues, and the hammer is in the bad behavior.
That's true. Maybe we should do another Rotary program and just debate it as a group. It really gets pretty complex. And being an attorney, I can argue it both ways. I think I'm most concerned that for the youth in our community, the consequence of this decision is to send a terribly mixed message, and one that I think is going to be damaging in a way that we're not going to really understand for years to come, unless they fix this quickly. And, my hope is that our legislature will see reason in putting a patch solution in place and adding the word knowing to the statute, even if just for a year, so they can have a more involved discussion regarding a broader solution moving forward that wrestles with some of these more profound public policy issues. But my fear is that politics is going to prevail, and we're going to have nothing happen, which I think is just going to be a real shame to communities across the state. And again, I think it's going to send a very confusing message to our youth.
Mark, that's my question for you, is whether there is anything that we as citizens can do in the legislative advocacy realm, because the repercussions that you've described, and thank you for such a comprehensive discussion of how far-reaching this decision is. And I would agree with you that the implications for youth are what really tug at my heart and really make me concerned about this, among the many, many disastrous consequences. But with such a simple solution in front of us on the legislative front, with Senate Bill 5468 and adding the word knowingly and addressing this mens rea requirement, is there anything that we should be doing in terms of contacting our legislators or otherwise engaging in somehow being part of the solution?
Well, there are, regardless of whether you support the House bill or not, the legislature does occupy a unique status in being able to take action to fix this if it wants to. And so if any of you are proponents of having the legislature fix this now by adding a mens rea requirement, you can contact your state representatives for the 24th Legislative District, Mike Chapman, Steve Theringer. You can contact Senator Vandeweghe, and you can say, I think this makes sense, and here's why. I don't know what their position is on this yet. My understanding from the folks I work with in Olympia is that the legislature is so busy and knee-deep in addressing law enforcement reform issues that they're not necessarily tracking this as an issue yet. The fact that it's even occurred on the one hand, much less the fiscal impact that could attach us to the state. But probably the best thing that people can do is to call their elected representatives. We operate according to a system of representative government, and express your opinion, regardless of what it is. Kathy.
What is the word on the street? I mean, this is the second time I've seen any mention or discussion, but I'm sure information like this goes out, and rightly or wrongly, you're probably already facing questions and having to make decisions.
Yes, this is a situation where the moment the opinion was published, the obligation for us to start taking immediate action attached. And so certain decisions were easy to make because, frankly, prosecutors are obligated to follow the law, regardless of whether or not we agree with it all the time. And so when the state Supreme Court declared that this was statute was unconstitutional, there's no question but that people who were being prosecuted for it needed to have that action stop immediately. People who were incarcerated needed to be released immediately. Bench warrants needed to be quashed immediately. Some of the more discretionary decisions involve the one I described in relation to how I'm going to be approaching minors in relation to smaller quantities of marijuana. And again, that's a tough decision because there is no good one. There's bad and worse as far as I'm concerned. And so we're still very much in the stage of trying to really take stock and inventory of the full impact of this decision. I think prosecutors are probably on the front line in doing that, along with criminal defense attorneys. Once the legislature learns more about this, I'm sure they're going to have something to say about it, and I'm confident that we'll read more about that in time. But I think they're so hyper-focused on just a raft of law enforcement reform bills that have been put before them and that are such a hot topic that this is, I think, deemed to be a fairly low priority for the legislature right now. Could change in as short as a week's time, for example. I see we're well past, and I just wanted to thank everyone. Again, this was not my intended program, but it's such a big deal, and I think it's difficult for the media to really report, given what John knows are column space limitations about the long reach of impacts. I just thought it would be helpful to kind of peel the onion a little bit to give people a sense and scope of what's happening. Also, because you'll probably see people in our community, and you may know about them from the newspaper as being people who are no strangers to the system, and they're going to be back out on the streets of the county again. And people are going to wonder, why on earth is that happening? Part of it has to do directly with this decision.
Thank you, Mark. Chris had to bail, so he's going to have me close the meeting. So I'm going to go ahead and adjourn the meeting. We can leave it open for a minute if people do have any more quick questions or they know how to get a hold of you, I'm sure. So, but thank you very much. That was informative. I missed the beginning, but since I recorded it, I'll go back and watch it.
Great. Thanks, Brian.
Thanks,
Thanks
Mark.
everyone. Yeah.